Good morning, everybody. Thank you all for joining us. We're going to wait a couple more minutes here to make sure everyone makes it in from the waiting room. I think we're almost there. There we go. All right. Good morning. Thank you all for joining us. I am going to start us this week, like I do every week, with some Zoom housekeeping tips, including a request that you all stay muted during the Q&A unless you would like to unmute yourself to ask a question. That's perfectly fine, but if you could stay muted otherwise, that would be great. It just helps cut down on background noise. Your audio and video button to mute and unmute and turn your video on and off are on your Zoom toolbar, bottom of your screen, probably depending on the device that you're using. We are recording today, which you would have gotten a warning about when you joined the Q&A this morning. And the reason we record these is because we put them all up on our YouTube channel. There's a message in the chat right now that gives you the link to the YouTube channel. So if you miss a couple of weeks or you submit a question and you're not able to make it in, or if you just want some really scintillating audio while you're running on the treadmill or doing your chores, you can go to our YouTube channel to find all of our videos for the last couple of years and queue something up that you think might be of interest to you. The message that's in the chat also tells you how to submit a question in advance of each week's Q&A. So pay attention to that and be sure that you get those in by 4 p.m. on Monday afternoon. That gives us the day on Tuesday to do any research that we might need to do in order to answer the questions. Speaking of answering the questions, I do want to just give a reminder. As we tell you every week, of course, we're not here to give legal advice. We're here to give general information. And we've had it happen a few times where Chelsea will email someone back and say, your question is too specific, or it's requesting legal advice and we can't answer that question. And folks will sometimes email back to argue with her about how it's not legal advice and it's not too specific. And maybe even that they're going to, go talk to one of us at a Q&A to kind of get around the decision that we've made not to answer the question. We do this obviously for free. We don't get anything out of this other than providing what we think is valuable education for our community in Washington State. And I will remind everybody that I'm the one who makes the judgment call that questions are too specific or that they are asking for legal advice. It's not Chelsea. And we just would remind everybody to please respect the fact that we are giving our time freely here, and you are not entitled to our time beyond what we are willing to give and what we are willing to talk about. So please just keep that in mind. We really appreciate and value everybody that participates in this Q&A, and just wanted to give you all that reminder. So again, not legal advice, general information. So also, if somebody sends you one of these video links and says, you have to do this thing or you can't do that thing because of something that Valerie or Jennifer or Ken or Diana, whoever, said during the Q&A, you can ignore that. And when you think, gosh, maybe that does apply in this situation, I wonder what we should do, and you need legal advice for your community, contact your association attorney, because they're the only ones who have that attorney-client relationship with you and who also, very importantly, understand things like your specific governing statute, your specific governing documents, and all of the particulars of any situation that you might be dealing with. A reminder that the chat is the best way to ask questions today or ask us to clarify something we've said. So please feel free to pop questions in there if you have any as we go along. We might have time for a question or two from the chat based on the number of questions that were submitted in advance. There's also an event reminder that I want to give everybody. We've been telling you about WSCAI's virtual law day, which is coming up on June 9th. And it is going to be a 4-hour virtual session. 2 of our attorneys are speaking at the event. There will be a lot of legislative information, lots of conversation about WUCIOA. So we think it would be a great event. We're excited to have some form of law day come back. I know a lot of folks have missed that since that event was discontinued. So we hope to see some of you guys there on June 9th. Another thing that we've been reminding folks about now that this year's legislative session is over is that the Legislative Action Committee continues to work during the off season. We meet frequently to workshop different ideas for legislation that we might like to bring, if we can find a sponsor to bring a bill that we think would benefit the community association world. And also just to continue building relationships, talking, negotiating with legislators that are proposing different bills that impact our community associations for the next legislative session. So although the legislative session is over, our work is not done. We're not, we're not taking a break until the next legislative session comes up. And if you do have changes that you would like to see made to the community association statutes, you are welcome to reach out to the Legislative Action Committee via WSCAI to submit your ideas. I can't guarantee that the committee will be able to take on all of the ideas that come to us, but one of the things that we hear a lot is, why didn't we know that this was happening when it was happening? And we're doing whatever we can to get the word out so that folks can be as involved in the legislative process as they want to be. So please keep that in mind and send your ideas to the Legislative Action Committee if you have any for us to consider. With that, I think I'm going to jump us into the first topic. And this is not a question that was submitted to us, but it's a reminder that is coming to you from all of us because of something we are seeing more often than we should, which is this reminder. Any association or board meeting that is held virtually, whether it's Zoom, Teams, or any other type of Google Meet, whatever it is, when you send notice of the meeting to your owners, it must include a telephonic option for members to join without having to use like the Zoom software or the Teams software, or without the use of even a smartphone, let alone a computer. That is required by the statutes. If you go to RCW 6490-445 subsection 3D, what it says is that any meeting may be held by telephonic, video, or other conferencing process if any person entitled to participate in the meeting is given the option of participating by telephone. And I'm a little baffled sometimes when I see these meeting notices come across our desk without a telephone number in them, because when you, for example, in Zoom, when you create a meeting and there's a thing where there's a button that you can click to copy the meeting invitation, it automatically includes phone numbers when you copy that text. So what this says to me is that somebody is parsing out or choosing what portions of that link, that information that Zoom provides you to include in the meeting notice, and they're taking the phone number out, which is contrary to statute. And depending on how compliant the rest of your notice is, and also what types of issues you are notifying your owners about and what might be discussed at that meeting, there are times when I think that defect, the failure to include a phone number, could be fatal to your notice process. It seems like a little thing, but it's very specifically and clearly required by the statute. So we just want to remind you, when you're sending out notice of board meetings, notice of association meetings, budget ratification meetings, any meeting that the owners are entitled to notice of, if it is conducted virtually, you have to include a phone number for them to call in to participate that way on the notice of the meeting. And with that, I will go ahead and cede the floor to Jennifer so she can keep us going.
So our next question is, other than lawsuits, what kinds of board or attorney communication is considered privileged and should not be shared in an open meeting? So privilege is very different. It's not by statute. It's through case law and the attorney's rules of professional conduct. So all communication between the association's attorney and the board is covered by that privilege. So the board holds the privilege. They can choose to waive it if they want to. But if they choose to waive it, it cannot be then down the road, if somebody has a problem with it, they can't take that back. So how this works is that the association buy-in through the elected board is the client. So the attorney can only give advice to the board, who is the client. How answers are worded and advice given can change depending on the explanation, can change depending on who is receiving this information. how I would word something to the board may be different than how I would word something that I know is going out to the community. There are times when my advice to the board is much more blunt than it would be to the community, or heck, this happens all the time. We have times where we tell the board we can give you there is legal justification for either side of this issue. Which do you want to do? Whereas if this was going to the community, we might say, well, this is the better option. It just depends on the circumstances. So, emails between the attorney and board members or managers. Managers are agents of the association, so they're included in the privilege. So emails are privileged. Invoices from the attorney, if they contain any information other than the billed amounts. So on our invoices, we'll have a description of the work done for that particular billing entry. That information is privileged. Memos and reports from the attorney are privileged. There is another part of this that's called work product. So, reports and investigations that are done at the direction of the attorney for the association are subject to the attorney work product doctrine, which means that it's privileged. But if the sorry, I lost my train of thought. If the board directs that a company provide a report or information, such as your reserve study, or you have an engineer come inspect your buildings, that particular information is not privileged and must be disclosed. If you have the attorney request specific information, then that could be work product. But again, there are different rules that apply in pretty much any situation. So if you have a question regarding a specific issue, please contact your association attorney. They can guide you through this. But just kind of as a blanket, for the most part, any communication between the attorney and the board or the attorney and the manager is subject to privilege. And then there's a question in the chat. Our management company emails something the client board can inspect. Um, it,
I don't think that's actually related to attorney-client privilege at all. That's a whole separate question.
yeah.
So I'll tack that on to the end of our list for today. And if we have time, we can get to it at the end.
Okay. So, Valerie, did you have anything to add to that?
I do not.
Okay.
I'm going to go ahead and take us to the next question. Is it permissible under Washington condominium law for a unit owner to charge their all-electric vehicle using common electricity, i.e., the cost is split equally among all unit owners? A charging station does not exist on association property. So there's no statutory answer to this question. However, if it is a common element outlet, the board has the authority to regulate the use of that outlet, and they can restrict an owner from charging on that outlet. The statutes about EV charging require that owners be allowed to have EV chargers, and those require that the owners pay for the electricity. Another practical consideration to keep in mind is that outlets that are not installed for the purpose of charging electric vehicles are different than even 120-volt outlets that are installed for the purpose of charging electric vehicles. And the way in which that they're different isn't necessarily so much they're structurally different, but an electrician will look at the load on the circuit that outlet is on and ensure that the electricity that's being drawn to charge a vehicle, which is really different than the electricity to run your hair dryer or your hand mixer or your alarm clock or whatever else you might plug into that outlet. An electrician that's installing an outlet for the purpose of charging an electric vehicle will be making sure that the load on the electrical system within that building is not overloaded, essentially, when you add the charging of an electric vehicle to that outlet. So it's permissible for the board to allow the electric cost to be a common expense. I don't think that would make most of your other owners very happy. And I also think this doesn't address the issue of whether it's appropriate from an electrical load standpoint to allow somebody to plug their car into just a regular old outlet that's not installed for that purpose. Um, we have clients that we run into this all the time. In fact, I was telling a story during our prep beforehand that when my now ex-husband and I lived in a condo before we bought our house, we had a limited common element garage, and he parked his electric car and charged in there all the time. And obviously the electricity was not paid for, it wasn't part of what was metered to our unit. So this is a super common thing. Um, one of the things that we've seen some of our clients do is make a private agreement essentially with the owner to pay a certain monthly fee to charge their car, but you should still install a dedicated outlet that meets the code requirements for charging cars. So you have the legal considerations and the financial considerations, but also the structural considerations that you need to be accounting for when you're trying to deal with this situation. So if you are dealing with this within your community, you'll want to consult with your attorney about adopting rules regarding the use of common area outlets. But you should also consult with your electrician about whether that particular outlet is appropriate for an owner to use to charge a car, or whether an additional outlet or a separate outlet on its own circuit should be installed. What you don't want to do is have the use of the outlet result in um, browning out the entire building, or other electrical ramifications that are not planned for when you're, not using that out or not planning to use that outlet to charge an electric car. I hope that answers the question. Jen, if you have anything to add, or Diana, please feel free.
I think you covered it.
Okay.
So our next our next question is regarding voting. So the individual is asking about 6438-120. So it's regarding in-person absentee ballots and proxies. They quote the statute. Is an HOA required to offer absentee ballots if the bylaws say that voting is done in person or by proxy? So you're conflating a couple different things here. The statute says that owners may vote at a meeting in person by absentee ballot pursuant to Section 3D or by a proxy pursuant to subsection 5. So absentee ballots are different than proxies. They are not the same. So absentee ballots are covered under 3D of the statute. The association is not required to offer absentee ballots. They can only be, the ballot must be provided by the association. And then the ballots must contain everything that's going to be voted on at that meeting, and they allow the owner to vote as if they were attending that meeting. They count for quorum. So proxies are covered under a different subsection. That's subsection 5 of this particular statute. And just as a reminder, this particular statute that we're discussing right now is 6438. This language is similar across all the common interest community statutes, 6434, 6490, and 6438 for no, that's right. The legislature also amended 6432 to include this language. So everybody is under language similar to this. So for proxies, again, the association isn't required to provide proxy forms. So, but if an owner submits a proxy that is compliant with this statute, and 64th, all of the common interest community statutes refer back to 2406, 110. So if the proxy complies with RCW 2406-110, it must be accepted. The statute does not require an owner to sign the proxy or have the proxy witnessed. It would allow proxies to be submitted by email. As long as you're able to trace back who the proxy is for, then the proxy must be accepted. And then a proxy itself either allows someone, a different person, to vote for that owner, or directs how the owner's vote is cast. So just kind of in a nutshell, proxies must be accepted if they comply with statute. The association is not required to provide a proxy form. Absentee ballots, the association must provide the form for there to be an absentee ballot. Valerie, Diana, did you have anything to add to that?
No.
Oh, nope, I have nothing to add. I will go ahead and move us to our next question, which is a short one. For Old Act condo communities, when does the law start that audits cannot be waived by the membership except for annual budgets under $50,000? Is it January of 2026 or January of 2028? The short answer to this question is that the WUCIOA audit section will not apply to non-WUCIOA communities until 2028, so January 1 of 2028. RCW 6434-372 requires audits which may be waived annually for associations under 50 units without consideration of the budget amount. So you've got your own section of your existing statute on when the audit is required and what you have to do to waive it. That is the section that you are governed by until WUCIOA for All takes effect in January 1 of 2028. And just in case folks are curious about this, the section of WUCIOA that deals with this is RCW 6490-530, subsection 2. And in 2025, the exemption amount or the budget amount that was required under which you could vote to waive the audit went up to $100,000. It's no longer $50,000. And again, this provision of WUCIOA does not currently affect non-WUCIOA communities. So if you're not a WUCIOA community, you need to Google your statute and the word audit to be taken to the section of the statute that you're currently governed by and look at your audit rules. And for WUCIOA communities, it's the statute that I just cited, and I think Jennifer just put it in the chat. Anybody have anything to add?
No. Okay. I can do the next question. It's a bit of a longer one, and it is in two parts. The first question says, our HOA was established under RCW 6438, and we have not opted into WUCIOA. We are on a calendar year and our annual budget is ratified at a meeting held in December prior to the new budget year. Our board is considering adopting a proposed special assessment before the end of the current budget year. I understand we need to follow the procedures for ratification of a budget as described in RCW 6490-525. But do we need to amend our annual budget for the current year to now include this special assessment? Or can we give notice of a budget ratification meeting for the sole purpose of ratifying the special assessment? The second part of that question is also, apart from the amount, due date, and purpose of the special assessment, is there any other information that must be included in the budget ratification notice for the special assessment? So to answer your first question, no, you don't have to amend your annual budget for the current year to do the special assessment, but you do need to follow the process under RCW 6490-525, subsection 3. And this applies to all associations today. And in response to your second question, special assessments must have budget disclosures similar to a regular budget. While you do not need to include the reserve disclosures, you must include income by category and also expenses by category and the amount of assessments per unit, obviously, and the date of when the special assessments are due, and whether the assessment is payable in installments or lump sums, or whether a discount for early payments can be applied. And to be safe, we also recommend you include the deficit in your reserves, which applies to each unit. I think that covers it. Valerie, Jennifer, do you have anything to add?
The only thing I would say is that for anybody that's curious about the budget ratification process, which also applies for special assessments, if you just look at the statute, and Jennifer just dropped the citation in the chat, 6490-525, It kind of acts like a checklist. And we've said this a number of times in the Q&A in the past, but it's a pretty clear roadmap for what you need to do, including the amount of notice that you have to give your owners in advance of the ratification meeting and the categories of information that you have to include in the notice that you send in advance of that ratification meeting. So when you're in doubt, look at the statute. I'm going to go ahead and move us to the next question. If a notice of delinquency with appropriate attachments is sent via first-class mail and the owner says they never saw the notice, what would be the proof that the notice was sent? And I'm going to start, I will get to the question about what's the proof. I promise I'll get there. Usually we do a short answer and then we go into all of our additional stuff that we want to say about the thing. But I'm actually going to start with the additional stuff first, which is that the statute does not require that the association be able to prove receipt or actual notice, just that you sent it in the manner that complies with the law, which is for the first written notice of delinquency, mail to the unit owner's offsite address if they have one, and email if you have an email address for them. And that's true even if they haven't opted into electronic notice. And if this feels like, whoa, we've never had to do it that way before, this is new in 2026. When you send an owner their first written notice of their delinquency, effective January 1 of 2026, this is how you have to do it. Mail to the unit, even if you know they don't live there, mail to their offsite address, and an email copy, even if they haven't opted into electronic notice. But speaking to this question, it's impossible for the association to ensure that an owner actually receives and then actually reads their mail. One of the things we were joking about it in our prep session was that if I had a quarter for every time a unit owner told me, but I don't read my mail, then I would have, not that much money, but a lot of quarters, because a lot of folks don't read their mail anymore. So you cannot prove or confirm or be held accountable for whether an owner reads and receives a notice. What you are held accountable for as an association is sending the notice in the manner that's required by law. Scenarios like this that I just talked about, where people don't read their mail, are probably part of why the legislature voted last year, and it took effect this year, to require that the first written of notice of the delinquency has to be sent in the ways I just told you: mail to the unit, mail offsite address, and email. As a reminder, also, that first written notice of their delinquency must include a copy of the statutory pre-foreclosure notice of delinquency. Now, as to the question of proof, the association needs to be able to show that the notice was sent as required by law, right? The easiest way to do this is to keep copies of your sent emails, of course, and also copies of the letters that were sent by mail, along with some form of proof of mailing. If you work with a management company, it is highly likely that they have mail logs that would be able to show when a letter was sent. If you are a self-managed community or a smaller community working with a management company that maybe doesn't have the mail log system, a copy of the stamped addressed envelope would certainly be evidence that you sent the notice that was required. And failing both of those things, a declaration signed by the person who mailed the notice saying, I mailed this notice to this person at this address on this day, is also evidence that you mailed the notice. So there are a lot of different ways that you can prove that you've done what you were supposed to do. One of the things that we say often in our practice, and if you've been participating in this Q&A for any length of time, you have heard me or Ken or one of us say, if it isn't written down, it didn't happen. And this is sort of a close relative of that, which is you need to actually have documentation. You can't fail to keep a copy of the letter, not have a copy of the envelope, not have a copy of a receipt from the post office for postage. Like, you can't just not have anything and say, but we mailed it. I promise we mailed it. I mean, you can, right? But then a court in that scenario, right, is evaluating the credibility of the person saying they mailed the thing with no evidence to show that they mailed it, and the person saying, I never got that. So what you want is something more than just a they said situation, at least ideally. As an aside, if you've got an owner who's saying they never got it, that means they're in contact with you, which maybe means there's an opportunity to resolve the delinquency, which really should be the primary goal. in all of this, right? And so if they are offering to bring the account current, if the board does something like, for example, waive late fees and interest, do it. We always, 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 barring unusual circumstances that I'm not going to go into now, recommend that when our clients are asked to waive penalties that do not represent an out-of-pocket cost to the association, in return for making the association financially whole otherwise, do it. And that eliminates then the question of the he said, she said, and did you send the notice and did I get the notice? And so, it just swipes the slate clean. It gives you a fresh start for any new delinquency that might arise. And then you can make sure that you're keeping documentation or evidence of sending notices, like we've mentioned here, for any future notices of delinquency that have to be mailed. You guys have anything to add on that one?
Nope,
Nope.
you've covered it.
Okay.
So our next question, and then we have one more question, and then we'll get to probably a few in the chat. So if you have any questions, please feel free to put them in. So the next question is, has there been a change tightening the requirements for assistance and emotional support animals? Based on something I read in the CAI members open forum, I got the idea that stricter standards were coming into play. Can this be true? And then there's some commentary regarding pets and animal fees, etc. So the article that's being spoken about is in the CAI advocacy blog from May 28th this year, reporting on a story from the New York Times. So the blog and the New York Times article just state that in an internal memo, HUD may be looking at tightening regulations for emotional support animals. So, but in order to actually change regulations, HUD needs to follow public processes and formal notice and rulemaking. So, to our knowledge, nothing is changed yet. We wouldn't recommend changing how you deal with requests for emotional support animals or any emotional support animals you have in your community until there's a formal announcement by HUD. As a caveat, we don't think needing support animals entitles an owner to an unlimited number of animals. And most rules about pet conduct still apply to emotional support animals. So if you have particular questions about an emotional support animal or how to treat emotional support animals in your community, please contact your community association attorney. But until there's absolutely something publicly distributed by HUD other than an internal memo, and HUD goes through the rulemaking process, we would not change how you treat emotional support animals. Valerie, Diana, do you have anything to add to that?
Yeah, I would like to add a couple of things. So when we first got this question, I did a little bit of additional research this morning, and I think it's worth pointing out that the Fair Housing Act has not been amended, and that can't happen until Congress actually changes the law. The case law interpreting the Fair Housing Act and also interpreting state laws regarding protections for animals like this have not changed. The memo that was circulated within HUD directs HUD staff to prioritize cases involving trained animals and to deprioritize cases involving untrained emotional support animals. It does not impact state law. It doesn't impact state agencies investigating housing discrimination claims. That would include the Washington State Human Rights Commission. State agencies and courts are not automatically bound by HUD's current enforcement position, and they can continue applying standards that recognize emotional support animals as reasonable accommodations. So I'm going to add my voice to Jennifer's and say that the bottom line for boards is that you should continue evaluating accommodation requests individually, continue the interactive process when additional documentation or information is needed, avoid taking an automatic approach to either approving or denying things simply because people use the right language, and absolutely, absolutely consult with your association attorney when you receive an accommodations request, especially if the request involves like unusual facts, multiple animals, questionable documentation or evidence to support the disability, or safety or behavior related concerns. Because as Jennifer did mention, rules about animal conduct within the community still apply to emotional support animals, as well as any other kind of accommodation animal that might be allowed in a community. All right, I'm going to move us on to our next question. This is the last one, but we've got a whole bunch in the chat, so I think we're going to have plenty to talk about today. Our association falls under WUCIOA, so we cannot vote in executive session. Sidebar: everybody is now subject to this limitation. This is not true for only WUCIOA communities. So effective January 1 of 2026, every single common interest community in Washington is subject to the WUCIOA meeting section. So this answer doesn't just apply to WUCIOA communities, it applies to everybody. So if you were going to check out because you heard we are under WUCIOA, don't check out because this applies to you too. You've mentioned in several videos that a motion and vote regarding money must identify the unit or the account in some way, though the board could use an account number or tax parcel number in order to make a unit somewhat less casually identifiable. I just want to confirm that after an executive session in which the board discusses a private matter regarding a homeowner or unit that is not about money, the board does not have to clearly identify the unit or homeowner in the ensuing vote held in the open meeting. Spoiler alert, that is not correct. I'm going to read the rest of the question before I get to the full answer. The two examples that I can think of would be an architectural review or an accommodation request. Accommodation requests especially might necessitate that the board keeps the owner's identity confidential to avoid violating the FHA, the ADA, or medical privacy laws. Another spoiler alert, you are not subject to either the ADA or medical privacy laws. But again, I'll continue with the question. Identifying the unit number or even the tax parcel number of an owner who has requested a disability accommodation feels like it might be too identifying. So, as you might have gleaned from my impertinent commentary during while I was reading the question, I think the short answer to this question is that almost universally, almost across the board, boards think more stuff is appropriate to discuss in executive session than is allowed or required by law. And boards are overly concerned about identifying a unit when they're voting in open session, probably more so than they really need to be. In other words, to put it really simply, most topics that you all discuss in executive session probably can be discussed in open session without issue. But absolutely without any doubt, when you vote in open session about a request from a particular unit owner, you have to be able to identify that unit in the minutes, both because otherwise, like, how do you even know what you're voting about if there's no identifier attached to the thing? But in particular, imagine your community is sued about that situation a year in the future, and then 2 years in the future, some judge is looking at your minutes from this board meeting, trying to figure out what the board discussed and what the board voted on with respect to, let's say, an accommodations request. How is the judge or a future board that was not involved or any other third party supposed to look at the minutes and be able to figure out which unit you were even voting on if you are not clearly identifying the unit, the property owner, the lot number, something to make it clear which property you're talking about? So getting into the nuts and bolts of this thing, there's no exemption under statute for executive session discussions of ACC or ARC requests. There's also no specific statutory provision that says accommodations requests should be discussed in executive session, although there is a sort of privacy-related catch-all in the statute that we think in this very specific and limited scenario, a board could decide that discussing an accommodations request in open session might violate an owner's privacy and could choose to discuss that in executive session. However, you still have to then come back into your open session and actually conduct the vote in open session. And again, both the vote, the motion, and then the way you record it in the minutes has to clearly identify the unit or the owner about whom that vote is taking place. And that doesn't mean that you have to say it's Mr. Smith and B102, but you as a community have to have a method of clearly identifying your units or your accounts. If you want to anonymize it as much as you can, if you work with a management company, their software likely assigns account numbers to each unit within your community. If you do not work with a management company, or if your accounting software does not do that for you, you can make up a list of account numbers and permanently assign them to each unit or property within your community, and have a list within your association documents that clearly identifies these account numbers for these units. And then you can use those account numbers as a way to provide some layer of anonymity or protection of identity when you're voting on things regarding each unit in open session. I think, again, we understand, in particular, when it comes to accommodation requests, the feeling that this information should be kept private, but it is not required to be kept private by the legislature or by federal law. And I do think it's important for me to non-flippantly say the ADA does not apply to community associations. The medical privacy laws and HIPAA definitely don't apply to community associations. And also those things have more to do with documentation. Like medical privacy laws have a lot more to do with things like medical records and how medical providers keep those private than how a board discusses an accommodation request in a board meeting. So while we understand the desire to be sensitive and the sort of inclination that this stuff is private or should be private, there isn't any legal basis for hiding this information in executive session and for voting in open session in a way that does not make it clear what you're voting on and for which unit that vote is taking place. I think that covers it. I don't want to beat a dead horse here, but Jen or Diana, if you guys have anything you want to add or clarify, please feel free.
Just briefly, when it comes to an accommodation, excuse me, an accommodation request, you should not be receiving medical records. The association at most can request a letter from a medical provider stating that the individual requesting the accommodation is disabled and what accommodations are required to help mitigate their disability. So a letter from a medical provider is not medical records, and associations should not be requesting medical records. That's information you do not need to have, and it goes beyond what you're allowed to ask for by statute.
Thanks, Jen. Okay, I'm going to jump us into the questions that were in the chat. Here's the first one. Our board has been asked by a seller's realtor if we allow adult family homes. In reading RCW 6434, which applies to our condo association, there is no mention of adult family homes. House Bill 5796, which was enacted in 2024, says it added a new section to 6490, but nothing about 6434 was mentioned. Does House Bill 5796 apply to everyone? And are we, until January 1, 2028, required to allow adult family homes in our duplex-style condominium community? I'm going to go ahead and take a stab at this one, and I imagine, Jennifer, you might have something to add. House Bill 5796 does apply to everybody because that's the WUCIOA for All bill, but that does not mean that the WUCIOA prohibition against banning adult family homes applies to your condo community, because those provisions of WUCIOA don't apply to everybody else until January 1 of 2028. As for what RCW 64 says about adult family homes, the only thing that I could find that was even remotely related to this is the childcare stuff, which says, and this is true in all of our communities in Washington, that you can't ban in-home daycares, but there's no language in 6434 that speaks to adult family homes. I can't answer the question of whether your community can ban or must allow adult family homes, because that would require a review of your governing documents. Jen, did you have anything to add on that one?
Just briefly, the statute in 6490 is 6490-585, and that's regarding adult family homes. So while that particular part of WUCIOA doesn't apply to everyone now, it will in 2 years.
Not even 2 year and a half now. I just had this weird moment the other day where I was like, I kept saying 2 years. Nope, it's a year and a half now.
Oh,
Don't panic.
geez.
Yeah,
So, for this particular question, you probably need advice for your particular community. Contact your community association attorney.
yeah. All right, next question from the chat. Are management company emails something the board can inspect? This feels like an overreach of the board. My short answer to this question is there's nothing in the condo statutes that speak to this. So I think this is an issue of look at your contract, and that's what governs the relationship between the association and the board, or between the association and the management company. But I'm curious if you have any different perspective on this, Jen.
Yeah, check your contract, but also when owners contact management company, the management company is the agent for the association, so they're acting by and for the board. So the board has oversight of the management company functions. There really shouldn't be anything in these communications that would affect any privacy or anything else. It's the community's information. Now, if you're talking internal, as in between management company employees, that's probably a little different. But anything that comes from the community, from a community member to the management company, I don't know why that would be a problem.
Yeah, it probably depends, right, on the context of what's being asked, right? The question says the board is asking to inspect management company emails. That seems really broad, and I don't really know what that means. If a board is saying, please give us copies of all emails to and from association members during the last 3 months or something, or the last month, or please make sure that the board receives copies of any emails you have with community members each month in the board meeting packet, that seems reasonable to me. It might be annoying and onerous, but they're not asking for anything that is unrelated to their community. If they're asking for some sort of blanket permission to audit management company emails with direct access to those, that seems different, and it really depends on the scenario. So I would say look at your contract and certainly reach out to your management company attorney on that, because there's not a whole lot in the statutes that speaks directly to this issue. All right, moving us on to the next question. If a board relies on a specific provision of 6490 and the association is not under that statute as of yet, except for those provisions that have gone into effect for everyone, does the board need to get owner permission via a vote to come under that specific provision of a statute it is not presently under? Anyone want to take a stab at this one, or should I run with it?
No.
Yeah, no.
Just no.
No, you don't have to vote, or no, you don't want to take a stab at it.
No, you don't have to vote. As long as the particular provision of 6490 does not conflict with the statute that you're currently under, there's no need to have an ownership vote whether or not to do that particular thing.
Unless you're trying to amend your documents.
Yes.
So like if you're actually wanting to amend your documents to bring them in line with 6490, that's an amendment or a restatement that would require a vote of your ownership. But if you're just saying something like, we're going to start conducting secret ballots that are consistent with the WUCIOA provision on that, and as long as it doesn't conflict with your current voting statute and with your current documents, it doesn't conflict, right? I don't think that you have to have an owner vote to adopt, voluntarily adopt provisions of WUCIOA, again, provided there's no conflict with your current documents or statute. we probably would need more specifics to be able to answer further than that. And that would probably require us to give legal advice. So I think that's probably as far as we can go on that question here. All right, next question. At a recent annual meeting, quorum of the owners was not met. At the time of the election, there were 2 openings. One of the owners present said those owners present could still elect someone by acclamation. So a new board was voted in at the meeting by acclamation. Is this a legal election? If there was not quorum, no association action can be taken, except for ratifying a budget, right? But like, so no quorum, no election. I want to be careful and say that, you know, this is a question that should be submitted to the association's attorney to get actual legal advice that you can that's, you know, that binding on the community and that speaks to their specific situation. But except for budget ratification, if there's no quorum at an association meeting, then no association business can be conducted, including an election. Anything to add, Jen or Diana? No? Okay.
No.
All right, we have one other question from the chat that I can see. One of the new House bills that takes effect June 11th affects resale certificates. My understanding is that one of the provisions is management companies have to offer alternatives for homeowners to be able to order a resale certificate from using a third-party service. Does this mean the management company needs to complete the resale in-house, or can the management company have the homeowner request their realtor to order through the third-party service? I'm going to go ahead and take this one just because of my legislative stuff. I want to say first that this statute hasn't even taken effect yet. It takes effect June 11th. And of course, because of that, we have no case law interpreting the statute yet. What the statute says is that homeowners cannot be required to establish an account with a third party in order to obtain or pay for a resale certificate. So I think 95% of the time when you tell people to go to HomeWise or Condo Certs or whoever it is you use for your resale certificates, they're just going to go do it anyways, and it's going to be a non-issue. But you're probably going to occasionally run into homeowners who are like, well, what about that statute that says I can't be required to have a third-party account? And in that scenario, it doesn't change who is preparing the resale certificate. You can still have Condo Certs or HomeWise or whoever it is prepare the resale certificate, but you cannot require the owner to go create a login and a password and upload their payment information to that third-party website in order to obtain the resale certificate. And we've had a lot of conversation in the Legislative Action Committee about what this means as a practical matter. Does it mean then that your management company, because most of the management companies, especially the larger ones that we work with, don't do resale certificates in-house anymore. They are often farmed out to these third-party vendors. Most of them are not going to start doing them in-house when this happens, but maybe what you guys are going to have to do is the owner contacts you and says, no, I'm not going to go request it from HomeWise. And because the association cannot force them to, then as a practical matter, somebody from the management company or the board maybe then has to go do the request for them. And then the management company pays for the resale certificate and then invoices the owner who pays the management company who then gives the owner the resale certificate. And what's really dumb about all of this is that this whole bill was proposed because there is a perception among some realtors that third-party providers like Condo Certs and HomeWise slow down the resale certificate process. And this bill is going to have that specific effect when people refuse to use the third-party providers that, to access them directly in that way. So I know that's not the clearest answer necessarily to your question, but the bill actually does not say anything about what management companies can and can't do. It's entirely about limiting what associations can force owners to do when they're asking for a resale certificate. And I guess it remains to be seen how much of an impact this statute is actually going to have once it takes effect. I hope that answers your questions. If anybody else has anything to add, now would be a good time. Nothing? Okay. that is the last question that we had in the chat. We got through a lot more today than I thought we were going to. So I think we're going to just end a few minutes early today. Thank you all for joining us, and we will see you all back here next week. Bye.